This is a video concerning Iowa unemployment compensation. This is a not-for-profit video. It is not sanctioned by Iowa Workforce Development nor by the state of Iowa. It is all from volunteer time. This is legal information and not legal advice. The topic is quit for good cause under Iowa unemployment law. There's a common fallacy that if you quit work, you cannot collect unemployment benefits. The statute and rules set forth specific reasons where you can collect benefits and where you can't, and there are a number of gray areas. What I'm going to go through today is the reasons that qualify an individual for unemployment benefits after a voluntary separation. Let's start out with the code section. Iowa Code Section 96.51 reads in part, an individual shall be disqualified for benefits. Voluntary quitting. If the individual, if the individual has left work voluntarily without good cause attributable to the employer, if so found by the department. So let's figure out what that says. The important words are left work voluntarily. That means that you quit. And without good cause. So it means you must quit with good cause attributable to the employer. And of course, if so found by the department, means that Workforce Development always retains jurisdiction to make this decision. Employers and claimants cannot make agreements on whether the individual should or should not get benefits. It is always the department's responsibility. Let's move on to 96.51a. And it reads in part, the individual left employment in good faith for the sole purpose of accepting other or better employment, which the individual did accept, and perform services in the new employment. Benefits relating to wage credits earned with the employer that the individual left shall be charged to the Unemployment Compensation Fund. All right, and what does it mean? There's a lot of language in there that's confusing. If someone quits to take another job, if a claimant quits to take another job, accepts the job, works at the job, the claimant is qualified for benefits, and the employer's account is not charged. So if you go out and find another job and actually work and earn wages in it, and then get laid off, claimants are qualified for benefits and the employer doesn't get charged. So that's why it's important that employers fill out their protest form to show if the person left for other employment. Now, this does not apply to self-employment. It only applies to work for insured wages. It has to be some type of employment where they withhold. Let's move on down to the last section, 96.51c. If I can get that a little better. This reads, if the individual left employment for the necessity and sole purpose of taking care of a member of the individual's immediate family, who was then injured or ill, and if after said member of the family recovered, the individual immediately returned to and offered the individual services to the employer, provided, however, that during such period the individual did not accept other employment. So, if claimant has a family member that's sick and needs to care for the family member, and claimant tells the employer what's going on and quits to take care of the family member. After the member recovers and after the family problem is resolved, the claimant must immediately return and ask for the job back. And if the employer doesn't have suitable work, claimant wins. Claimant gets benefits. But it must be for a member of the individual's immediate family, and it must be for a current illness. And once recovery is there, the claimant must come back and ask for the job. So you need to follow those elements. Let's move on to the next page. Go to Iowa Code Section 96.51d. The individual left because of illness, injury, or pregnancy upon the advice of a licensed and practicing physician, and upon knowledge of the necessity for absence immediately notified the employer or the employer consented to the absence. And after recovering from the illness, when recovery was certified by a doctor, the individual returned to the employer and offered to perform work and the regular work or comparable work was not there. Claimant wins if fulfilling all of these requirements. First of all, it must be illness, injury, or pregnancy, and a doctor must say you can leave. And you must immediately notify the employer. Or the employer agrees you need to take time off to get your health back together. Once recovery, the claimant has a duty to get a doctor's note and bring it back saying, I'm ready to work back to full duty and do my old job. And it has to be immediately. You can't wait a couple weeks or a couple months. Claimant must do it immediately. And bring the doctor's note back in. Claimant brings the note in. If the employer doesn't have suitable comparable work, claimant may be eligible for benefits. Let's move on to the next section. We're on E. And E is a little bit odd. You don't see very many of these kind of cases. And it reads as follows. The individual left employment upon the advice of a doctor for the sole purpose of taking a member of the individual's family to a place having a different climate, during which time the individual shall be deemed unavailable for work, and notwithstanding during such absence, the individual secures temporary employment. Then, and of course, must return and ask for the job back once the problem is resolved. Now, this is a little different. Many of these rules where you're allowed benefits because you have to take some leave of absence, you can't take work in the interim. This one says you can have temporary work while you're off, moving a family member to a different climate. But as with everything else, once the problem's resolved, the claimant has a duty to immediately return to the employer to ask for suitable and comparable work, and if none is available, then benefits are allowed. And then we can go down to the next one, and this one is one that talks about compelling reasons for leaving. It's 96.51F. The individual left the employing unit, meaning the employer, for not to exceed 10 working days, or such additional time as may be allowed by the employer for compelling personal reasons. So, the crucial words in this is you left for not more than 10 working days, or additional time is allowed by the employer. If there's a death in the family, ask the employer for a month off. They grant a month off because it's a compelling personal reason. And if the claimant overextends that, then it's a quit that will disqualify. Must comply with the employer's additional time or must be back within 10 working days. And of course, there's always notice requirements. You need to inform the employer of the compelling reasons and immediately afterward return to ask for the job back. Most of these provisions for voluntary quits require that a claimant inform the employer and immediately return to work and ask for their work back once the personal reason or health reason is resolved. Now, in this one, it says that during the time the individual is away, the individual's work, because of the continuance of such compelling reasons, shall not be eligible for benefits. So what that really means is, while you're away for compelling personal reasons, you can't collect unemployment. Then we go to 9651G. This is a requalification provision. It is what's called a 10X requalification. And what this says is if you leave employment, you quit for a reason that does not amount to good cause, and the next job you have, you earn enough money that's equal to 10 times your weekly unemployment rate. So for example, if you earn $200 a week on unemployment, and you got disqualified by employer Acme, and then you went to employer Beta, and in Beta you earned $2,000. That would negate the prior disqualification. So if Acme disqualified you because you quit without good cause, the next employer you gave wages of $2,000 to the claimant. Claimant is now requalified because the claimant earned 10 times the $200 weekly benefit rate. It's a $350 weekly benefit rate. Claimant must earn $3,500 from one of the subsequent employers or all the employers put together. It doesn't have to be just from one employer. It has to be subsequent. So, for example, if claimant quit without good cause on January 1, 2010, if at any time after January 1, 2010, claimant earns 10 times that weekly unemployment rate, with all employers put together, at that point in time, claimant has requalified for benefits. Let's go to the rules. Under Chapter 871, there are a number of rules which say when claimant can quit for reasons that amount to good cause attributable to the employer. And the first one talks about resignations. And it says where the claimant gave the employer an advance notice of resignation which caused the employer to discharge claimant prior to the proposed date of resignation. No disqualification shall be imposed from the last day of work until the proposed date of resignation. However, benefits will be denied effective the proposed date of resignation. And that bears some explanation. There's a lot of words in there. What it says is if a claimant quits and gives the employer 2 weeks, 3 weeks, 4 weeks notice. For example, if a claimant quits on the 1st of the month and says, I'm going to quit, my last day of work is the 30th of the month, and the employer says, no, you're not going to work till the 30th, you're fired today. Claimant is eligible for benefits from the 1st until the 30th, the last day that claimant said that they would work. Then as of the 30th, it's a separation. And then that separation will be determined whether it was good cause or not. So benefits will be denied or granted then on the 30th depending on the reason for the quit. If it was good cause attributable to the employer, benefits may be allowed. If it was for a reason that disqualifies and is not good cause, then from the 30th on, benefits are withheld. But what it does is protect claimants from getting laid off or losing benefits during a time when they are ready, willing, and able to work. The next one on Rule 40. Now this is under Chapter 871, our Administrative Code, Rule 24.25, and we're on the subsection 40. And it reads, where the claimant voluntarily quit in advance of the announced scheduled layoff, the disqualification period will be from the last day worked to the date of the scheduled layoff. Benefits shall not be denied from the effective date of the scheduled layoff. So what this is if there's a layoff, for example, if there's a layoff starting on the 15th of the month, and claimant says, I'm not going to work till the 15th, I'm going to quit today on the 1st. Benefits are denied from the 1st till the 15th. Then on the date of the scheduled layoff, because it is a layoff, would qualify claimant for benefits. Claimant gets benefits on the 15th. So quitting in advance of a layoff, benefits are denied until the date of layoff. Let's go to 24.26.2. Voluntary quit is left due to unsafe working conditions. And this is a kind of a tough case for proof for a claimant's case. Must prove unsafe working conditions. And unsafe, usually violations of OSHA rules where claimant has made complaints to an employer and the employer did nothing about it. Those are the kind of situations which may be unsafe. But it must be, claimants have a tough proof problem on those, and it's usually difficult. They need to have some good documented evidence and some good witnesses to prove an unsafe work condition. The next is whether claimant left due to unlawful working conditions. And there's a variety of things you can come up with. I'm not even going to touch on what an unlawful working condition is because there are so many situations which could be considered unlawful. Nevertheless, if there's something going on at work that is unlawful, whether it be criminal or civil, it doesn't even need to be criminal, that is good cause attributable to the employer. Another proof problem for claimants. Let's move on down to the next. And this reads, the claimant left due to intolerable or detrimental working conditions. Intolerable or detrimental, meaning detrimental to your health and well-being. Intolerable means something that nobody would want to put up with. And some examples are excessive use of profanity, claimants being called names by a supervisor repeatedly, where claimant makes complaints to upper management or personnel, human resources, and nothing's done about it. Continued use of profanity and name calling is just unacceptable. Hazing is unacceptable. And there's a variety of things that are intolerable and detrimental. I'm not going to get into too many fact patterns on this because it really depends on the circumstances, the type of work, the job, and the repetitive nature of the infractions. Finally, we go down to separations because of illness, injury, or pregnancy. And this has to do more with work comp than anything else. Back up a bit. Get this adjusted for a second, and then we'll move on to... Generally, if a claimant leaves work because of non-work related illness, they need to have a full duty work release to come back, and we went through that in the statutory code. If it's a work-related injury, it's a little different story. So let's talk about an employment-related separation. The claimant was compelled to leave employment because of an illness, injury, or allergy condition that was attributable to the employment. Factors and circumstances directly connected with the employment which caused or aggravated the illness, injury, allergy, or disease to the employer, which made it impossible for the employee to continue in employment because of serious danger to the employee's health, may be held an involuntary termination of employment and constitute good cause attributable to the employer. Claimant shall be eligible for benefits if compelled to leave employment as a result of injury suffered on the job. There's a lot in here. The bottom line is it has to be something, injury and illness has to be caused or aggravated by the work and cause a serious danger to the employee's health. Or if compelled to leave because of an injury suffered on the job. When the doctor says you can't come back, or there are work restrictions that telling claimant don't come back to work. And if we move on down, it gives some clarification. In order to be eligible under paragraph B, an individual must present competent evidence showing adequate health reasons to justify termination. Before quitting, have informed the employer of the work-related health problem and informed employer that the individual intends to quit unless problem 2 is corrected or the individual is reasonably accommodated. Reasonable accommodation includes other comparable work which is not injurious to the claimant's health and for which the claimant must remain available. So, as with most of the quits sections, there's a duty to notify the employer, give them a time or an opportunity to remedy the problem. Always give notice on all quit issues as to what's going on so the employer has an opportunity to resolve the problem. When it's work-related, a work-related health issue, it generally requires, it's generally good sense for a claimant to try to get a doctor's note saying that it's going to aggravate your health, that it's serious danger to your health, that you should quit, that you have work restrictions which cannot be accommodated by the employer. Then the claimant should go to the employer and let them know so the employer has a chance to do something about it. Let's go down to these layoff provisions and see if I can get focused in a little better here. Okay, and this is similar to the labor dispute. A claimant who, when told of a scheduled future layoff, leaves employment before the layoff date shall be deemed to be not available for work until the future separation date designated by the employer. After the employer designated date, the separation shall be considered layoff. So if there's a layoff coming in the future, and claimant decides I'm going to leave ahead of the layoff, that time benefits will be denied for that time. You don't get benefits if you leave a week or two or even a few days in advance of a future layoff. The employer has the right to designate the date of layoff. Claimant has a duty to work up until that date, and if they leave earlier, they get denied benefits right up to the date of the layoff, and then benefits are allowed as of the date of layoff. That's the general rule. And let's move on down and talk about the next. This is under section 20. We're on Iowa Administrative Code. Chapter 871, Rule 24.2620. The claimant left work voluntarily rather than accept a transfer to another locality that would have caused a considerable personal hardship. Now, get transfers to other localities. Generally, at the time of hire, most claimants know if they have an opportunity or a chance that they're going to get transferred. And that may cause this issue to turn one way or the other. Nevertheless, the salient language is considerable personal hardship. Claimant has a burden to prove a personal hardship caused by transfer to another locality. For example, if claimant is caring for an elderly member that is in the community and the employer wants to transfer them 200 miles away, that may very well be a personal hardship. Finances may be a personal hardship. There's any number of reasons, and it's all fact dependent. So claimants need to be ready to establish all the reasons that were caused hardship by the transfer to a new location. Now, this next issue is subject to debate. There is a split of opinion on this, and it reads, claimant was compelled to resign when given the choice of resigning or being discharged. This shall not be considered a voluntary leaving. So if you quit in lieu of being fired, the employer comes in and tells claimant, you're going to get fired, but I'll give you a chance to resign instead. One opinion on this is that's an automatic qualification. Another opinion is that it's no longer a quit, it is a discharge, and it shifts the burden of proof to the employer, and the employer must prove that they would have discharged claimant for misconduct. So claimants should be ready to argue that the employer was conferred a benefit, a legal benefit, by getting a voluntary resignation, that the resignation insulated the employer from liability. Employer should argue that we were going to fire them and it was for misconduct, and then the employer has the burden of proving misconduct, so they would have the second bite at the apple to prove that claimant should be disqualified for a discharge for misconduct. Then we move down to work that was misrepresented. Number 23, claimant left work because the type of work was misrepresented to such claimant at the time of acceptance of the work assignment. So if an employer misrepresents the job at the time of acceptance, not after, this is when the job is accepted by claimant. So for example, if an employer tells the claimant that this is a sales job, you will never need to cold call. Once claimant accepts the job based upon the terms that no cold calling is necessary, gets to work, and the employer says you need to cold call 50% of the time. That is good cause for a quit because the employer misrepresented the job. Now there's gray areas here, because if the employer comes in and says, well, no, you don't have to cold call, but once a month or 6 times a year you need to go out and do a cold call. It's very occasionally. That may not be good cause attributable to the employer for a quit. So there's gray areas in there, and there's ways for employers and claimants to argue both ways on that. The facts, it's very fact dependent, and your employers and claimants should be prepared to argue both sides of the case. Now we get into some legal issues here. Occasionally, 24.28.6 deals with issues where these cases come out with double decisions. If a claimant files for unemployment benefits and then exhausts that year and then files a new claim for benefits, sometimes duplicate decisions will come out on the same separation date. Once a separation date is adjudicated, once a decision is issued on a separation date. For example, if a claimant worked for Acme and they were fired on December 1st, 2010, and a decision comes out and says claimant is qualified because of the December 1st separation date. That decision becomes final because nobody appeals it. That is a final and binding decision. Claimant comes back a year later, files for unemployment again. Sometimes that December 1st date will come out with another decision. and it will say claimants qualified for benefits December 1st. That is a second decision. There's no second hearing can be held on that because it was previously adjudicated. And that's what Rule 24.286 says. So this usually happens when claimant files for benefits during a second year. And that rule is just to cover, so when that decision comes out, there's a way to dispose of that case that really shouldn't have been there. It's usually an accident that a second decision comes out on the same separation date. You can only have one decision or one chain of decisions on every separation from employment. You can't re-adjudicate it a year later. That is what I want to say. These are all reasons or discussions on why and how an individual can receive benefits after they voluntarily quit. In a later video, I will go through reasons that are not good cause attributable to the employer for a voluntary quit.